In an unexpected turn of events, Fulton County District Attorney Fani Willis's disqualification from the Georgia election interference case involving President-elect Trump and his allies has incited considerable speculation regarding the continuation of the prosecution. Though the charges remain intact, a state appeals court's recent decision to disqualify Willis and her office has intensified the current legal conundrum, coinciding with Trump's anticipated return to the White House. Legal experts suggest that the ruling could severely jeopardize the case's future prospects. Anthony Michael Kreis, a law professor at Georgia State University, aptly describes the situation as an omni-shambles, implying that the case could very well be heading toward a bleak conclusion. The Georgia Court of Appeals panel made a controversial 2-1 ruling, citing Willis's previous romantic involvement with Nathan Wade, a key prosecutor in the case, as a critical factor that necessitated the office's disqualification due to apparent impropriety. This overturned a previous ruling by the trial judge, who had allowed Willis to maintain her prosecutorial position on the condition that Wade stepped aside, a condition he had fulfilled. Uncharted waters, remarked Chris Timmons, an experienced trial attorney in Atlanta, reflecting on the unprecedented nature of this appellate decision. It is rare for an appeals court to disqualify a district attorney's office. In a bid to rekindle her prosecution efforts, Willis is now appealing the disqualification decision to the Georgia Supreme Court, a move accompanied by uncertainty due to the court's majority of justices appointed by Republican governors. The Supreme Court must first determine its willingness to review the appeal, a decision with significant implications for the case's revival. Legal expert Timmons acknowledges the faint chances of the case proceeding but maintains that hope is not entirely extinguished. Should the state Supreme Court intervene to dispute the appellate court's judgment or wipe our hands of this, as Kreis puts it, a potential resurrection of Willis as the lead prosecutor is feasible. Conversely, if the Supreme Court abstains, the legal chapter may conclude, leaving the Prosecuting Attorneys Council of Georgia, PAC, to determine the case's destiny. Pete Skandalakis, PAC's executive director, remains cautiously reserved, noting that all channels for appeal have yet to be exhausted. The PAC's potential involvement might see the case redirected to another district attorney's office. Complicating these developments is Trump's incoming presidency, which poses a significant hindrance to any ongoing prosecution. Legal consensus dictates that the case cannot progress during Trump's term, thereby postponing any prosecutorial pursuits until 2029. Trump's defense team relishes the disqualification, considering it a cessation of politically driven actions against the forthcoming president. The news has gathered celebratory responses from Trump's co-defendants. Former Justice Department official Jeffrey Clark jubilantly shared his sentiments on a podcast, and Harrison Floyd, a pro-Trump advocate, expressed his delight via social media. The decision has spurred further discourse on Willis's accountability, with calls from figureheads like Floyd advocating for her disbarment to thwart future prosecutorial overreach. As the legal drama unfolds, it captivates attention nationally, foreshadowing potential ramifications on prosecutorial ethics, political entanglement in judicial matters, and the broader implications of judicial disqualification decisions.